forward. So explain to me why this one is different and why this one should create a new little niche. Why?
You guys said it best. This is a whodunit. A completely circumstantial case.
People versus Manuel Vega.
Y le tocó a Manuel ese caso.
You may proceed.
Good morning, everyone. My name is
morning.
Justin
Good afternoon.
Bones.
Good afternoon.
We've been here a while.
Actually,
It's okay.
I've been up
It's
all
almost
night.
Friday. Go ahead.
It is. Good afternoon. May it please the court, Justin Bones
afternoon.
on behalf of Manuel Vega. I was really considering how long I actually really needed to argue here because this is a narrow issue. It really is. And I believe this court does know this case very well because it was in front of this court in 2004. And I without question, I believe that DNA testing there is a reasonable probability that a different result would come about from DNA testing here. Now,
Isn't that wishful thinking, counsel?
Your Honor,
Isn't
you're a
that
little-
wishful thinking in light of all the circumstantial evidence and the DNA testing that already took place?
well, I didn't hear the last part.
She said, isn't it wishful thinking?
No, I don't think it is wishful thinking. And I think that is a good question, though. And the reason why it's not wishful thinking is every time a court grants DNA testing, it's about discovery. We don't know if the DNA is going to be on the item that we're asking to be tested. And I want to
But
correct the lower court.
Would that not just
Excuse me,
show?
I'm sorry.
Sorry, that there was someone else present in the apartment at some time prior to the murder, right?
Right.
But we know that from the
Yes.
testimony. We
Right.
know that there were other people there. That's what people testified to.
Yeah, the brother lived there, the cousin lived there. We know that.
Right, that's correct.
So DNA testing would not even, let's say you're right, that DNA testing would show the profile of another contributor. Even that, though, doesn't tell us when that contribution was left in the space, so that it could be at any time. It doesn't point to a lack of guilt in any way.
I respectfully disagree.
Okay.
I'm not asking for like a hair that's found in the corner of a room that could have been left by somebody. I'm asking to test the pillow that was used to suffocate Ms. Vega. And that pillow was found in the marital bedroom. It wasn't found in the other two bedrooms. It was found in the marital bedroom. I'm asking to test and let me be clear here, because Judge Clancy at the end of her decision says that we're only requesting male-specific DNA. No, that's not what we're asking for. We're asking to do touch type and trace DNA just like gun cases are done every day in this city. So we're asking to test the pillowcase that was used to suffocate Ms. Vega. We're asking to test the gown that she was wearing, and even the ME states that it looks like the person that committed this murder used the pillowcase to suffocate Ms. Vega and actually was on top of her. We're not asking to test things that we're not involved with. We're not shooting in the dark here.
Wasn't this tested already?
That's great.
No,
wanna
but
ask
I'm
I don't wanna
going
ask a question because
I'm
I heard
going
it. Don't ask a
somewhere because under the statute, is there a are you entitled to a second test?
How can you test something that you didn't have the ability to test in the first place? Back then, there was no ability to test, touch type, and trace DNA.
So
the
that's
question-
a new method.
That's a new method.
new method.
So
Correct.
so every time there's a new method, the courts have to allow all evidence that was utilized in criminal prosecutions and then allow all of that evidence or part of that evidence to be retested on the hope and the prayer we might find something? Don't we need something more than that?
Not all cases, just this one.
So, counsel,
Good comeback.
Good try.
But tell me why this one stands apart.
Because
Because I have to use a decision here I have to think about its prospective use going forward. So explain to me why this one is different and why this one should create a new little niche. Why?
You guys said it best. This is a whodunit, a completely circumstantial case. And Powell even talks about that, where even an unknown profile could give you a third-party
So
culpability.
counsel, how does this differ from People versus Concepcion, a 2013 case where the court found that additional testing would at most show that someone other than the defendant or the victim was in the apartment? A highly speculative theory is not the basis for DNA testing. I mean, we do, as my colleague pointed out, we know, my colleagues, plural, pointed out, we know that two other people were residing in the apartment. We already know that. So what's the grounds for additional testing?
Again, it goes back to what we're asking to be tested. And there were 3 additional fingernails, like in Bush. Bush required retesting on nails that even augmented in Bush the third-party culpability argument. Here, there is a question about identity, and the testing that we want to do is about specific items that were involved with the murder. And interestingly, like when you look at Brady, and I know I'm kind of, this is a little different argument. Brady talks about evidence that could have been used to investigate further. This is a discovery motion. Ultimately, I get the evidence and I make the argument, okay? And ultimately, it's what a single-minded defense counsel would do with this evidence. And to say...
But counsel, the standard really here is that there be some probability that the verdict would have been more favorable to the defendant if the retesting was ordered. The retesting would show, yes, a third person, but what we're lacking here from all of the other evidence would be any other person's motive.
Yeah.
Well, potentially, and I don't want to say potentially because I don't want to open the door that wide, but again, this goes back to there were 3 bedrooms in this house, okay? The back bedroom where she was found and his cousin lived in. There's another bedroom that was unoccupied, and then there was the marital room. The pillow itself was only found in the marital bedroom.
Also, but isn't there a history of domestic violence here?
There is. There's also a refuted history of domestic violence.
Right, he said everything was fine, but there was testimony, at least from one neighbor, that the wife came to her in a bloody mess twice in different years.
And stayed there several days until he convinced her to go back.
Yeah, and her employer saw her also bruised, that she couldn't go to work that day. You know, she was sent home. So I don't understand when you're saying there's a disputed domestic violence history here. He did say that everything was good with his wife.
He did.
Yeah.
He did.
All right, you'll have time on rebuttal.
Absolutely. Thank you.
Good afternoon, Your Honors. May it please the Court, 88 Josh Weiss for the Office of the Bronx District Attorney. Your Honors, the motion court was correct to deny defendant's sweeping request to compel OCME to conduct additional DNA testing on the crime scene evidence. The motion was an improper attempt. The motion was an improper attempt to obtain retesting of.
Well, counsel, is it really retesting when the test that he's asking for did not exist at that time? It's testing in a different form, right, with new technology.
That is absolutely correct, Your Honor. But I would note that this court this court held in People v. Espino that the statute simply does not permit retesting. It does not allow defendants, convicted defendants, to avail themselves of modern or more sensitive.
The statute doesn't provide for retesting, is what Espino said.
I'm sorry, Your Honor.
The statute doesn't provide for retesting, not that the statute doesn't allow retesting.
It doesn't prohibit it, it just doesn't
No, you're right.
require it.
You're right, Your Honor.
So why shouldn't
by the text of it,
why
it doesn't
shouldn't we allow for this retesting, seeing as this method was not available at that time, and as we know, the more time goes by, the better the testing gets. So why not allow for the testing of this under this new method?
Because I think Judge Clancy got it right in concluding that there wasn't a reasonable probability of a different verdict. Of course, given the number of people who had access to the apartment, it is conceivable that DNA could be found on any one of the crime, any piece of the crime scene evidence if it were retested.
And there was
Although, I mean, to the extent that your adversary says, in particular, we want the pillowcase that we know is alleged to have been used to suffocate this victim. I have a lot of visitors come to my house. People don't touch my pillow. So the fact that there are other people in the house should not mean that there are fingerprints on my pillowcase unless you were supposed to be in my bedroom, right? So why not test the pillowcase?
Sure, Your Honor. Well, I would just note that it wasn't that people were merely present. There were people who were actually staying in the house, residing in the guest rooms for several nights a week.
right in the guest rooms, not in the marital bedrooms. And then we had a witness who testified that he was in and out that night when the murder allegedly happened, the same night.
Right,
Murder
correct.
happened, not
Correct, Your Honor.
allegedly.
The defendant's cousin. My answer, Your Honor, is that even if somebody else's DNA were found, it doesn't negate the extensive evidence of domestic violence that defendant exhibited toward the victim in the years leading up to it. It doesn't negate his statements to the police in which he admitted that he was at the apartment at the time that the murder occurred, according to the examiner.
And let's talk about that for a minute. 'Cause
Sure.
It seems to me that one of the strongest pieces of evidence, or the lack of evidence as a result of the statement, was the statement by the defendant that he had had sex with his wife, and yet when she was examined post-mortem, there was no semen found in her.
That's right, Your Honor. And as this court found on direct appeal, that appeared to be a ruse intended to conceal the strained nature of their marriage, the deteriorating state of it in the years leading up to it. And it really dovetailed with the evidence of domestic violence, that this was an abusive relationship that unfortunately culminated in Miss Vega losing her life at the defendant's hands.
Counsel, where was the body found? In which of the rooms?
So the body was found in a second guest room beneath a futon, wrapped up in 2 comforters. The trial testimony established that at least 2 other individuals, defendant's cousin and defendant's brother, would stay in that room several nights a week.
And according to the defendant himself, he has slept in his bed with the victim that very night.
Yes, that was his version of events.
That was his version of events. And they had sex that very night, correct?
Correct.
And then he left sometime in the early morning hours
To go to work, right.
to go to work. And the pillow that they want retested, where was that pillow found?
I believe that pillow was found in the defendant's bedroom.
In the defendant's
In
bed.
the defendant's bedroom.
What was the estimated time of death?
The ME estimated between 10 and 11 p.m. There was a possibility that it occurred sometime thereafter, but she said that it was unlikely the further away you got from midnight.
At a time when the defendant said he was sleeping with his wife?
Around that time, between 10 and I think he said he got up at 1 or 1:30 to get ready to go to work.
And the cousin, I believe he was moving out, he testified that he did not see the wife that night.
So the cousin was in and out of the apartment about 3 times that day. He came back at about 7:30. I think he conversed with the victim and the defendant. When he came back later that night, around 11 and 11:30, everything appeared normal. The house was quiet. From his standpoint, it appeared that everybody was asleep.
Including defendant and the victim. Where they would have been in their bedroom at that time.
Yes. Based on the defendant's version of events, they were both asleep.
Thank you.
Thank you, Your Honors. We ask for an affirmance.
Just briefly,
You have 2 minutes, go ahead.
The ME testified that time of death could have been as late as 9 o'clock in the morning, which would have had my client would have been at work. It was pretty well established when he went to work. We roughly left around 2:20, I believe, and then arrived at work at 2:30. and
So he was supposed to be meeting a neighbor
At 8.
at 6-something that day so that they could go job hunting.
Right.
And that neighbor called on her that morning and got no answer.
Yes.
And
My client called well, you're
first
right.
the neighbor called and got no answer.
Yes,
And
that's
then your client called the neighbor, and the neighbor said, "Well, I called and I got no answer."
right.
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 And your client called sometime after 9, around 10 o'clock or so.
Yes.
I believe he called 7 the first time, and then I think it was 10. It was 10 o'clock in the morning. Yes, correct. That is correct.
And just getting back to what the medical examiner testified to, the medical examiner pointed to the condition of her corneas being cloudy, and the doctor said that usually does not occur until 24 hours after death, which is why she thought that the death occurred closer to 10 p.m. than later.
I understand that. And one of the things that I know from doing this for quite a while is that time of death is all over the place. You can have a 12-hour window on time of death, especially when you have somebody that struggles, the heat of the room. I mean, there's
But
all.
all of this was brought out at trial. Even those arguments that time of death might have been different, and the retesting that you're specifically looking for doesn't necessarily mean that there couldn't have been a conviction or that there was more likely that there would have been an acquittal, because we have all this other evidence that the jury heard it and they came up with a conviction.
I didn't hear the last part, Your Honor. What was it?
All the other evidence that's there, that you're talking about, that we discussed, the time of phone call, the time of death, maybe the difference that there wasn't the time of death, all of that was presented to the jury. How would retesting of the pillowcase change all of that other evidence that's already there, that would make it seem that there would be more likely that there would have been an acquittal? Because again, of all this other evidence. Did I not ask my question correctly?
Yeah.
Yes,
Oh,
I was getting ready to. I was going to answer.
He's formulating his
You're
answer.
pondering, go ahead.
Formulating his answer.
I know where you're going. That's a great question.
Third time.
But so if the cousin's DNA is found on that pillowcase, that doesn't change everything.
It doesn't tell us when the cousin's DNA got on the pillowcase. And
What if the cousin's watching TV with his cousin on the pillow? We don't know.
The pillow is never the pillow is in the marital bedroom. There's not a single shred of evidence that somebody goes in the marital bedroom. There's not a single shred of evidence
except your client.
except for my client, right? So
Maybe that's exactly what the jury thought.
and you know what? I'm going to have to live with that with DNA testing. It wouldn't be the first time I would be wrong.
Right.
But I would be willing to test that. Are we going to let a man sit in jail for something that he didn't do? Or are we going to just test it? Doesn't justice, this is where.
so then when we get back to that point, your position is that we should now implement this law, that when new forms of testing come out,
Right.
this should be our case law, when new forms of testing come out, people should be entitled to retest, even if there's no other reason other than new forms of DNA testing now retest. And I think that would be something that maybe some people can argue before the legislature, because they can write that into the law, into the statute. But that's not what we have right now.
I will say that's where I this is different than, I don't want wholesale here. This is different. We have evidence of another party that's.
No, we don't. We don't. That is your argument.
That is my argument.
That's your argument. I don't believe that there is evidence of another party. But we have your briefs, and we will consider them thoroughly.
Thank you.
You have a good day. All right.